Good morning, everyone. This is Judy Watman. I'm the Director of Education for the Pennsylvania Apartment Association, and welcome to the PAA webinar, Employment Issues During the COVID-19 Pandemic. We know this is a difficult time for people in the property management industry, as well as in all of our communities. We hope this webinar will bring some clarification on issues that we face as a result of the coronavirus pandemic and resulting changes in our personal and professional lives. So just a bit of housekeeping for our webinar today. Please type your questions into the question and answer box at the bottom of your screen. We will be answering questions as we go through the slides, and we have reserved time at the end for additional questions. Rob, can you move up to the disclaimer slide? There we go. So we just wanted to review a disclaimer. The coronavirus crisis is a fluid, dynamic situation. Details are changing rapidly and new information is being learned every day. In addition, most of us are in uncharted waters, so best practices are being written in real time. What we are presenting is our best guidance based on what we know today. Each individual company and manager will need to make their own decision based on their property and business needs. Nothing presented today should be considered legal advice or mandates by PAA or any of the presenters. You should check with your own legal advisors and consultants on what is best for your business. So let me now introduce our speakers. Rob Dustin and Dina Callow are attorneys with the law firm of Saul, Ewing, Arnstein, and Lair. They both have extensive experience in human resources, employment, and labor issues facing property management companies and are associate members. Please welcome them to our webinar.
Good morning, everybody. Judy's right. This has been a very challenging time for the industry and for employers, and we hope over the next hour we will be able to provide you with some guidance over the Families First Coronavirus Response Act, which goes into effect tomorrow. And what we've done is really give you some hypothetical examples and questions and answers to give practical advice. We hope also if you have questions, you'll type them into the questions and answers box. And if we're not going to already answer them in our presentation over the next hour, we will try to answer them for you. We're going to talk for about 45 or 50 minutes and then leave some time at the end for questions. There's so many changing parts. The Department of Labor, just as an example, issued a set of FAQs. They issued one last week. They extended those by another few questions and answers on Friday, and then issued more questions and answers over the weekend. So everybody's trying to give advice, and we are going to try to do the same over the next hour. So our roadmap, we're going to talk about some employment issues and some guidance generally on coronavirus practices. We are then going to talk generally about the Families First Coronavirus Response Act, the FFCRA, which really did two things and gave two new paid leaves to employees. One's a sick leave and one's an extension of the already existing FMLA. And then we're really going to go through some practical examples and hypos to help you understand how this might affect your employees and you as employers. And then again, we're going to go through some questions. So we're going to start first with an example that I've gotten already from an industry client, but I think we're going to see some more of this. So let's start. So our first example, the receptionist. So Julie is a 19-year-old receptionist at Community Contractors, which provides cleaning, maintenance, and other support services to residential and commercial properties. She calls her supervisor to say that she is concerned about leaving the house and doesn't want to come to work. Her supervisor is frustrated and asks whether Julie is sick or has been exposed to COVID-19. When Julie says no, her supervisor tells her she better be at work tomorrow or she'll be fired. And I want to preface this by saying we're assuming in this example, Community Contractors is an essential business. which has become really a critical analysis in all of the states who are issuing shelter at home or stay at home orders. So community contractors is an essential business and must stay open. So the questions: does Julie have the right to stay home just because she's afraid to come to work? Is she eligible for any paid sick leave under the Family First Coronavirus Act? And what about unpaid leave or a furlough? I know everybody's been hearing about furloughs, which is a word probably nobody has used in ages and ages. And would it make any difference if she has a documented anxiety disorder, which potentially could be a disability under the Americans with Disabilities Act or state law? So, answers. Again, assuming that we're talking about an essential business and a business that has stayed open, she does not have a right to stay home simply because, hey, she doesn't want to come to work and she's afraid. She doesn't qualify for any of the Family First sick leave because she does not meet any of the conditions which we're going to talk about in detail in a few minutes. She can only take personal leave or PTO, paid time off, if it's permitted under your existing company policies. And again, remember, your policies are going to typically specify requirements for how much notice an individual has to give, unscheduled leave, emergency leave. That's going to follow what your other policies follow. So employees who just call out, you need to give certain periods of notice. And those policies need to be followed even in these times of crisis. Since the business is open under state law, she can and should be required to come to work. Now, if Julie does have a documented disability under state or federal law, here we would call it anxiety disorder, she may be eligible for leave as an accommodation and certainly may have a serious health condition under the Family and Medical Leave Act. If we think that she has a anxiety disorder or a serious health condition, there are certain requirements that we as the employer have to go through. So for example, we can require documentation from her healthcare provider, which may pose its own challenges right now, but telemedicine is up and running and we can ask her to get that documentation. And that will include how long she's going to need leave. Those leaves typically are not paid leaves, although that will be dependent on the state and your own policies for short-term disability and things like that. But again, this is not the family's first leave that goes into effect tomorrow. So unless she has paid leave under a company policy or state disability, this is going to be an unpaid leave of absence.
Dina, we have a question. What if she is pregnant?
So that's a good question. But again, just saying that she is pregnant, so that potentially puts her in a high risk environment, right? Under the coronavirus high risk. And we should potentially have her get a doctor to say that she should not be coming to work. We are going to talk about those high risk exposure issues in a few minutes. And certainly I think the issue would be she does not want to be exposed to the virus. And we can talk about leave issues and accommodation issues, but that may fall into the ADA or potential family leave concerns that we've discussed. And we're going to get there. The high risk exposure under coronavirus is going to come into play. So the next question here is, what if she states she has an underlying medical condition? And can you require her to appear at work until the documentation is submitted? What we've done, and this goes back to the Americans with Disabilities Act, there are forms that she should have to fill out. And what I would tell you generally is I would not have her come to work if she is expressing disability related issues. I would have her I would give her a reasonable period of time, a few days, because of telemedicine. You can generally get those forms filled out pretty quickly by a telemedicine doctor. have certain information that you need from the telemedicine doctor filled out, that she has a condition, that she needs an accommodation, and how long that accommodation needs to be in order for the individual to be out of work, and the length that she needs to be out of work.
So let me jump in.
Please.
So this is Rob Dustin. Good morning, everybody. So these issues about employees who are fearful of coming in. Remember ancient history 3 or 4 weeks ago when this was just starting and all of the advice from CDC was out there for pandemic preparedness and for keeping employees who were working, sick people should stay home. And CDC just had all of those best practices of hand washing and sanitation and everything else for your offices. Then we had our wave of closure stay-at-home orders that, at least initially, were all designed to flatten the curve, to spread out the pandemic and spread out the illnesses and give some time for, if not containment, at least to slow things and get prepared and get testing rolled out and the next phase. At some point here, we are going to be returning people to work, not just in necessary businesses, and the virus is still going to be around until there's a vaccine or herd mentality. So those same issues you were facing 3 or 4 weeks ago when you had people in the office and some people anxious and scared are going to roll back, and that will include assessing the risk of individuals who have underlying medical conditions. And you're going to be asking the question, and we'll be talking about this throughout, at what point is your workplace unsafe for a particular employee, even if you're following best practices? So this may seem moot to most of you right now, unless you're in a necessary business, but it's not, and it's going to be continuing throughout this year. So at this point, we all are aware of the basics. It's been ever present for weeks, and while we're getting more information daily with a more sense of how quickly coronavirus will usually show up after exposure. Most doctors are finding in the earlier studies it's within 5 days, but we still have our rules that it could be 12 to 14 days after exposure for symptoms to develop. We still have the recommendations on our vulnerable populations, 60 or 65, depending on who you talk to or which doctor is opining. And we are learning a lot more information, but of course the disease can be serious for younger populations as well. The guidance from CDC has not fundamentally changed. We still have out there, independent from the stay-at-home orders and the actions being taken to slow the spread, the basics on safe practices in the workplace and what to do after exposure. CDC has not changed since the start of the pandemic almost 2 months ago, or the start of the virus spread. All of those risk assessments, and then if you have an exposure in the workplace, and if you're running a necessary business right now, you may have exposures. You may have people who had an exposure while they were at home or when they come back to work. And you have to just analyze the risks to your population, sanitation practices, reporting and coordinating with what the local public health authorities say. And these are all those issues you were looking at on risk assessments and how to keep people at work and keep them safe. If you're not doing them right now with an open workplace, you will be at some point here in a month or two. So let's move on to our next hypothetical, leasing agent. So Maria works at a complex and just came back from a trip to New York City to check on her family. She calls her manager to say she has a cold. Manager tells her to stay out for 2 weeks until she gets a doctor's note that is negative for COVID-19. So is the manager assuming that Maria has a disability under the ADA? Can the manager do this legally? Does she have a right to be paid? Very common situation right now. Well, under the EEOC's pandemic guidance, which first came out in 2009 after the H1N1 pandemic, at that point, EEOC came out with guidance which they updated last month for COVID-19. And what EEOC says is that this manager is assuming she might have a virus that will typically have a short duration, can be very risky for some. And as a result of the duration, it would usually not be a disability under the ADA or state law. And this, even if it's just a cold, it might not be a serious health condition. You don't know based upon these symptoms alone. However, the ADA regulates all medical exams and inquiries, so even if it's not disability related, there are some basic restrictions. And in a pandemic, the EEOC says you have a right to keep all sick employees stay home until they're symptom free. You have a right to take actions to protect your workplace and to ensure return to work releases. We'll talk about those in some other examples. So the question comes, if Maria's symptoms resolve in a few days, do you have a right to keep her out, however, for 14 days? Now, she may be able to get a negative COVID-19 test. She may not be able to get one. Doctors are still rationing those at this point. So you would have to make the decision, even if she reports that she's symptom-free. Do you want to keep her out until there's a negative test or until the 14-day period? Or are you going to allow her back with a doctor's note or some other kind of release? Normally, she wouldn't have a right to paid leave of any time, unless you have rights, as Dina said, under your policies, existing PTO, existing leave that she can take. But if you're in that magic spot here of 50 to 500 employees that are actually below 500 employees, then under the Family First Act, she may be entitled to the 2 weeks paid leave for that first 14 days that you send her home. It's not just because you send her home. She should be able to get a doctor's note that says you are placing her under self-quarantine at home because of possible exposure. So that may qualify. Next scenario, somewhat similar, different question. So Harold arrives home from an overseas trip that he took. He's come down with flu-like symptoms, and in this case, he has tested positive for COVID-19. He was sent home for isolation. He was not hospitalized. A week later, he's feeling better but has a cough. He thinks it's because he has underlying asthma conditions, but he wants to come back to work because he's feeling better. So, should he be allowed to come back, and what can you require? And this is really a good question. We know if the 14-day period is the incubation period, it's not the recovery period. There's a lot unknown on how long an individual can be contagious or not. Some individuals will be sick for weeks. The CDC says that this is a case-by-case decision and that you really have to defer to public health officials and the individual's own doctor. The gold standard for somebody who has COVID that the CDC recommends is symptom-free without any medications for 24 hours and 2 negative COVID-19 tests taken within 24 hours apart. And until that's available, that's what CDC requires before releasing somebody from the hospital, and recommends the same thing happen to anybody who is on self-isolation. What happens if Harold can't get to a doctor for 2 negative tests? With this current rationing, we're going to talk about that a little bit later. So, legal and HR issues. Dina, you want to pick up here?
Yes. So we've talked a little bit about some of these legal and HR issues that are going to come up. We're going to run through some of them here. We talked about the Americans with Disabilities Act. Does the person have a disability, meaning, do they have a impairment that substantially limits a major life activity? Or, as we say here, are they a direct threat to themselves or to others in the workplace? And that's an interesting question now with this pandemic. It's one that hadn't come up a ton prior. We've always talked about direct threat. That would come up where somebody's riding, safety sensitive equipment and has epilepsy, for example, right? Are they a direct threat? Can they do their job? Here, if an individual has COVID-19 or potentially has COVID-19 or has been exposed to it, we're seeing a lot of these direct threat inquiries because is there now a direct threat to the workplace, and what do we need to do to accommodate that direct threat? And that kind of came up in Rob's last example. FMLA, we're going to talk about that, but is COVID-19 a serious health condition? Meaning, is it a condition that is treated by medication? It doesn't sound like it. And I think that's why what we'll see is that there's been this creation of a new example, some new examples of paid sick leave. There's a new creation of this childcare exemption of FMLA. But whether this COVID-19 actually is a serious health condition under the FMLA really remains to be seen. I'm not sure that it is, because generally colds and flus that can't be treated by medication are not serious health conditions under the FMLA. It really depends on if it requires hospitalization and things like that, and how long they last. However, the federal government, with these new implementations of laws, are certainly creating other ways to protect people's jobs, and the states are also doing that. So in Pennsylvania, certainly in New Jersey and in New York, there are laws being created almost every day, different executive orders, which are protecting people's employment if they come down with COVID-19. And then there's different labor relations. So those who have collective bargaining agreements in place, and remember, even if you don't have a union, if there are individuals who are grouping together and engaging in protected concerted activity or activities that involve their terms and conditions of employment, we need to be careful that that would be protected by the National Labor Relations Act as well. So there's a ton of legal and HR issues that are involved now with COVID-19, and we need to be cognizant of them, and certainly get legal advice from your legal advisors as these issues are coming up.
So there's also,
can you look at the questions?
I will. As Rob's talking, I'll look at them. Okay. I've been trying to answer them as we go along. Go ahead, Rob.
So there's also a panoply of wage and hour issues, and we're going to be using some of those during the various Q&As. You've got all of your existing, and this is not easy stuff to figure out on how all these laws overlap, particularly when you add the new ones with the existing ones. You've got your own PTO, vacation, and sick policies that were pre-existing. You've got mandatory sick leave policies in various states, including New Jersey. You've got the federal FLSA, which says, as a basic rule, that my non-exempt employees are not entitled to be paid if they're not working. But if you've got exempt employees who are staying at home and working from home or working reduced hours, they have a right to their salary. You can reduce salaries, but only if they're going to be off work completely, or do you not have to pay your exempt employees. And if you decide to reduce hours instead, most states have some provision for partial unemployment for reduced hours, and we're all going to be learning a whole lot more about partial unemployment than we have usually dealt with in the past. The other thing that's going to be the interesting overlay that most businesses outside of manufacturing and construction haven't paid, and healthcare haven't paid a lot of attention to in day to day, is the OSHA General Duty Clause. Occupational Safety and Health Act does cover all employers, and the basic duty clause, there's no specific OSHA regulation for COVID-19, but OSHA has come out, and we have a link to this in the resources at the end, with a couple statements about all of the different rules that can apply to COVID-19 situations in the workplace. And the umbrella one is the General Duty Clause that basically says you're obligated to have a place of employment that's free from recognized hazards that are likely to cause serious physical harm, and to comply with any specific standards. And here's the basic doctrine. If you fail to keep your workplace free of hazards, and the hazard was recognized and was causing serious harm, and there was a way to correct it, then you have violated the General Duty Clause. This, this was applicable before the stay-at-home orders. It will be applicable it is applicable to any of you who are operating as necessary businesses or as your employees come back. And in all those situations, the key here is following, in the absence of any specific requirement, CDC guidance. And CDC's guidance says, keep sick people out of your workplace. Anybody who's sick or who with symptoms that might be COVID-19, keep sick people out, and to maintain and sanitize and follow best practices, including social distancing, physical distancing where possible. But if you're following CDC guidelines in the workplace, you should not be liable for violation of the OSHA general duty clause. Where this is going to come up is not just in probably less risk with OSHA than possible workers' compensation claims after people get sick at work.
Rob,
So
I have some questions about prior slides, so I'd like to jump in and let's ask them now before we move on further. And I just want to remind everybody, if you're typing in chat, can you type in the question and answer box? That's the one that we're monitoring. But going back to the trip question, the individual who took a trip and got sick and now wants to return to work, what procedure should be taken upon the return of an employee who went on a trip? What's the recommendation for what we should do before we allow that person to return to work? I know we talked about kind of getting 2 tests that are negative, but isn't that going to be impossible these days?
Sure, that's going to be impossible in the short term. So before that, you should, at a minimum, insist on a return to work release from their doctor. And that doctor should be talking with public health authorities about understanding when that individual who was tested positive for COVID-19 is going to be considered safe to return. And you can keep that person out till you get a return to work release. If you don't trust the doctor, you could take temperatures of employees before they come back to when they come back to work. That is permitted under the EEOC guidance, but of course not all COVID individuals with COVID-19 are going to have high temperatures. And once this person is tested positive and free from symptoms, that's not going to change things. You're really going to have to rely on the doctor's return to work release. Once they are released back, they are considered safe, and nothing further that you need to do or should be doing with them.
Okay, and there's a couple questions about time increments under the Families First Act. So what increments of time can be deducted? I don't know that we talk about this. I'm going to let's hold off on the FFCRA questions just for a minute until we talk more in detail about the act. So I'm going to hold off on those.
Okay. All right. So next hypothetical. Changing gears slightly here, but still dealing with our employee issues. So John does maintenance at the property. He responds to the Smith's apartment to deal with clogged toilet plumbing, notices Mr. Smith is coughing in bed. John leaves, tells the property manager, I don't want to be in the resident's apartment due to fear of coronavirus. So do you have to comply with John's request to not let him work at the Smith's apartment? Do you have a right to refuse to do repairs of residents who are sick to protect their employees? Does it matter what type of maintenance that they are doing? And so the simple answer is no. John doesn't get to choose where he works, so long as you're following precautions to keep your employees safe. Now, in this case, you have a right to protect your employees, to do a risk assessment, to find out what Mr. Smith has, to ask the residents questions about his illness. Has he been diagnosed? Is he showing other symptoms? It may just be, it's still flu season. It could be sinus infection, or it could be something else. And even if it's COVID, there are steps that you could take to isolate those individuals and sanitize the rest of the department and let John go on in to fix the plumbing. And so there are steps that could make that a safer workplace to go on in and do that. There are steps you could take. But you have to reassess the risk to John if he's in a high-risk population, either because of his age or an underlying condition. You have to consider alternatives. Do you have somebody else who is at lower risk that could do these? How does the type of repairs matter? That's a question not only under the lease agreement, but also, you know, what is really an emergency and what can be deferred. And
I just want to jump in,
yeah,
Rob.
please do. Yeah.
A lot of our clients are also thinking about alternative ways to guide residents in this area. So can we be offering how-to videos to do some of the more minor repairs to not expose the employees to any risk? We're offering, you know, iPads or FaceTiming with residents to ensure that they can offer solutions without having to go into the properties. So there's a lot of creative ways to engage with residents on these maintenance issues for issues that are not significant or emergent. But, you know, if you have, you know, a flooding issue because the toilet or sinks are running over, you know, we have a bigger issue and we have to deal with it. And how can we deal with it in a safe way? That's going to be more significant. So I think you have to try to, in these times, be very creative in and assessing the risk on both sides. So how do we, you know, how do you do that while assessing risk to residents and assessing risk to employees, but also getting the essential jobs done?
Okay, well, this is one of those times when all of those business interruption, business continuity, crisis management plans that you have in place for hurricanes and natural disasters and other situations, you're having to adapt and adapt on the fly, and to a much broader and of unknown duration. But all the basic principles of any disease or disaster preparedness plan on your lines of communications with your employees, determining who's essential and unessential, figuring out who can do what, all of the things that you've been doing to adapt to stay-at-home orders and restrictions over the last 3 or 4 weeks, and looking at how that is going to continue throughout the duration of this pandemic and perhaps waves of up and down activity and restrictions. Dina, anything else you want to add?
Sorry, I was answering a question. Sorry about that. No, but I think that, you know, we have to, again, this goes back to how we are thinking about our business operations and ensuring that, you know, we are thinking creatively. You know, a lot of clients that I'm talking to now had never before thought about working from home, right? Their initial reaction to work from home was, no, we can't work at home. But again, you know, as we think about our new environment and as we think about the Families First Act and, you know, one of the things that we can do under the Families First Act is there a teleworking option? Because if there is, then we don't have to necessarily pay sick leave or the family leave. And so at the end of the day, you know, can we think more creatively? Do we need to have the same work hours that we had before? And in some instances, the answer is yes, we do, because we have operations that we need to maintain from 7 to 3 or from 8 to 4 or 8 to 5. But are there ways to split shifts with different people, or are there ways that we can work differently in the world we live in now to ensure that our employees still have jobs and are still working, but that we can work with our residents, with our maintenance staff, kind of in a different operation to keep everybody safe and working in the time that we're in?
Yeah, one of the examples Dina mentioned yesterday was expansion of video leasing. A lot of you are online for many of your operations and with availability for prospective residents, but adding virtual video tours of homes instead of and units instead of individualized walkthroughs. and thinking about how to continue to fill those units now and throughout the rest of the year. So let's switch gears to what we've been touching on a little bit with the details of the FFCRA, which goes into effect tomorrow. Basic rules, paid sick and family leave.
You know what, Rob, I'm just going to jump in again.
Yep.
For those of you who are typing questions in chat, please type the questions in the question and answer box. Thank you. Go ahead,
Okay.
Rob, sorry.
So takes effect April 1, expires at the end of this year. It is a short-term leave law unless extended later. Mandatory paid sick leave and paid family medical leave for covered employers. And one of the key aspects of this one is that there is a dollar-for-dollar tax credit that can be used immediately when you start having employees request to use this leave. And as Dina mentioned, the questions and answers, there's the link there. It gets updated on a regular basis. Covered employers, most with fewer than 500 employees. Those with fewer than 50 may have an exemption that can be documented why you don't have to do this. But if you've got fewer than 500, you are covered. Larger employers are not, on the assumption that they have other paid leave policies that are equivalent. There are some exceptions for available for healthcare providers and emergency responders. And most public sector employers, state and local government employers, the exceptions are mostly on the federal government side.
Rob, let me just jump in. For those who are under 50, there's been very little guidance on the type of documentation that you need to provide. In the FAQs that were issued by the DOL, it basically said, you know, keep documentation. Rob, can you go back to the last slide for a second?
Yep.
It said, you know, that you should be keeping documentation demonstrating that complying with the law would jeopardize the viability of your business. But there's really no guidance on what that documentation would be. So it's really important that whatever you think that documentation is, you keep it for your records, so that in the event that there's some enforcement action brought or some employee claims that you're not paying some sick leave benefits that need to be paid, that ultimately you can demonstrate that you did that in good faith based on what you knew and the size of your business. So we've had a few questions about that. I can't be any more specific because there really has not been any more specificity about that. But that's what we know so far. We expect that there will be some more on that later. And then the other question, and again, this is more for your accountants and tax people, you know, the people that are helping you with your taxes. But with regard to the tax credits, it's my understanding, and Rob, help me here if you can, but it's my understanding that you get to retain the payroll taxes that you would normally pay to the government that you take out of your employees, the payroll. Again, I'm no tax person, but this is not something that you have to apply for and get back later. It's actually money that you would normally send in to the government for taxes that you are going to be able to keep. So that's real money and dollars in your pocket when you pay these funds, correct?
Correct. So if I've got 100 employees and I have 2 employees who are taking the leave starting tomorrow or next week, I have to pay their salaries and continue them at a reduced amount for those 10 days each. But I can start withholding what I would otherwise be paid to the government for their FICA and FUTA and Social Security off the top for all 100 employees. And I'm retaining that money that otherwise we would be paying into the government as real cash. Obviously, the smaller you are and the more people you have who are seeking this relief, it's not always going to work to recover it immediately, and it may take some time. So there could be cash flow issues, and those are the kinds of things you need to talk about with your tax advisors. So the basic rules: 80 hours paid sick time for full-time employees, pro rata for part-time. yes, no matter what your other policies are, if you have part-time employees, they are entitled to this emergency paid leave. It is capped with different levels for the paid sick leave, and both on the amount per day and the total amount that employees can receive over the 2 weeks. There are 6 covered reasons, and only 6 covered reasons for this emergency leave. First is quarantine or isolation order related to COVID-19, and we think that is a fairly narrow definition, but we just don't know. Typically, a quarantine or isolation order is an individualized order. DOL has not come out with any further guidance yet about how the stay-at-home executive orders would apply, but we think that Congress's intent here was individualized or group quarantine or isolation orders for individuals or families. But the broader one is when a healthcare provider says somebody should self-quarantine due to exposure. So that's just a doctor's note saying, you have possible exposure, you need to stay home for 14 days. And that documentation, which will come eventually, that would qualify. Third one is if I'm just having symptoms and I need to go to a doctor, I get the leave right up front, paid leave until I can get into a doctor to see whether I have the virus or not. Care for a family member that covers under any of those, and then the child care aspect. Put quite simply, the first 2 weeks, you have up to 12 weeks of family medical leave that we're going to get to for child care purposes, but the first 2 weeks of that can get covered as paid leave under this law, and then the 10 weeks the other 10 weeks kicks in after that. The other rules that we know that from the FAQ so far, employees can use this sick leave before using anything else. It's their election. You can't force somebody to use their PTO or vacation or sick leave. They have the right to use this new sick leave first. You have a poster, all covered employers, not uncovered, but the covered employers have to post a poster, and suits will be brought under the FLSA. Now the other one, while the paid sick leave portion is a standalone new law, the other one is an amendment of the FMLA, and it is an expansion act of the FMLA with some differences. It applies to all employees who've only been there 30 days. It's for leave when they cannot work or telework because of the need to care for a child because their school is closed or their child care provider is closed due to COVID-19. This is probably going to be the one that is most used between now and the end of the school year from all of those jurisdictions whose schools have been closed and parents are now both trying to work or telework from home and homeschool their children. And we believe that every one of those situations is probably covered under the FMLA Expansion Act. This is 12 weeks of total rights. The first 10 are unpaid, but employees get to choose whether or not they want their sick or vacation leave or PTO or to use their rights under the paid sick leave expansion. And after that is a 2/3 rate of pay, but with the lower 200 a day and a maximum of 10,000 over the 10 weeks. So anybody using these expanded FMLA rights, it's $200 a day, but for up to 10 weeks past the initial 2. Again, reasonable notice, and like the FMLA reinstatement rights, there are some exceptions, but the DOL FAQs are showing that they are treating this for lots of purposes. I mean, it is an amendment to the FMLA, so a lot of the rules and concepts that apply to the FMLA are going to apply to this expanded leave rights as well.
Rob, now we have some questions, and I think we should go through them.
Sure.
Okay, so under the FFCRA, does paid sick leave or emergency family leave cover employees if an elder care nursing home or the person caring for their elderly relative is responsible for their care? Are they covered? So I think that question means, is it only for the child, right? Caring for a child or caring for others?
It is a child care leave. I do not believe it covers the elder care. It does. A child has been interpreted in the same way as the FMLA, so it can include adult children with disabilities, as the FMLA does. So care for somebody in that situation would be covered. Your regular FMLA
Right.
may cover care for a sick family member for elder care purposes, but not just because their nursing home or assisted living facility is shut down.
And under the sick leave portion, the 2 week sick leave, if you have to care for a family member, is that covered? And what family members?
It is a, I'm trying to remember, Dana.
Me too.
It is a fairly narrow
Narrow definition.
definition of family member for the paid sick leave portion. My recollection is it's, spouse, partner, legal child. Yeah.
And that's
Or
it.
child or legal guardian. Yes.
Yeah, I don't even think so. So for the sick leave portion, the question is, does this cover anyone, neighbor, coworker, third cousin? No, it's
No.
just immediate family member.
Yeah.
I don't even think it's parent. I'm going to look while Rob's continuing to talk. I think it's your spouse or your child, and that's it. But remember, like Rob said, the regular family medical leave is still there. That's not paid coverage. That's just guarantee of your job upon return, assuming, let's all hope, that the job is still there upon return. So we have to just remember that these are extended coverages and give you pay, but the FMLA, which is a job guarantee and health benefits continuation, still exists, assuming that the individual has a serious health condition. And I want to go back to something I said earlier, right, about the serious health condition under the FMLA and whether COVID-19 is one of those. So we've been hearing all over the place, right, that sometimes COVID-19 is very minor and a person stays at home and they're, have kind of flu-like symptoms for a few days and they get better. Generally, that's probably not going to be a serious health condition. On the other hand, we've heard other cases, the more serious ones, where individuals are in a hospital and they're on a respirator and that sort of thing. Those individuals, if there's one night in a hospital, that is a serious health condition. So there's a lot of variation in this illness, and depending on that variation, it may or may not be covered by the regular FMLA, not this emergency FMLA. And whether that coverage exists is going to be the expansion of who is covered, right? Who you're caring for is going to be there. So now there was another question. What increments of time can be deducted for exempt employees for the Family First Act? This person heard 1 day increments. Do we have to establish, and they have an established PTO policy. So that gets to a different sort of issue relating to intermittent leave under the FMLA, right? And under this extended FMLA, and whether an individual can take this FMLA, instead of taking it all at one time, can they take it 1 day at a time, or even down to an hour at a time?
For the child, and for this additional reason, what DOL has said so far for the child care leave is that intermittent can be done if the employer agrees. It is not written in the DOL guidance as a right the way intermittent leave is under other portions of the FMLA. And that was part of the FAQs that came out last week on that intermittent issue. The deduction from PTO is of your own PTO is a different pure FLSA question.
Okay. Can an employee request to use their PTO in lieu of Family First Coronavirus Act to prevent reduction in pay due to the cap? This is an excellent question, and the answer is different.
Sure.
Dependent on the sick leave, whether they're doing the sick leave or the PTO. So I think we have to kind of analyze both. I'm going to leave it to you, Rob.
Yeah. Well, yeah. If your own policy, if they have PTO or sick leave under your policy, or even can use vacation for this purpose, right up front, they can request that to be used. but you can't require them to use it first. But if they are requesting to use that and they're not exercising their rights to job protection, then it's just a question of your policies. If they want the job protections, they basically have to say, I'm taking the paid sick leave now. So they have a choice there on what they use. They can keep all of it, but you can't require it.
And I just want to, so let's talk about this for a minute, right? So there's paid sick leave, which is if I have the coronavirus, if I've been exposed to it, if I'm quarantined because somebody I know has been exposed to it and I was in contact with them, or if I'm caring for a child similarly. So all those exposure issues. What that law basically says is, I get up to, what was the max, 500 some odd dollars, or my full salary, right? So that's that cap that we're talking about for 2 weeks. And then those are the first 3 reasons. What the law says there is, I can't require somebody to take their own time. But certainly if the person says, hey, I don't want that. I have all this sick time and I prefer to take my sick time so that I get full pay. So they can voluntarily do that. I'd want to make sure that I get from them some consent form that says that was their option. As the employer, though, as far as we understand right now, if they do that, you don't get the tax credit. Mm-hmm. And that's something to understand. Yeah. The other issue is then the child's school is closed and they're taking time because the school is closed. They actually get both forms of leave as a result of that. They get the sick leave and they get the extended FMLA leave. And they get it for a full 12 weeks, okay? They get the sick leave for the first 2 weeks, they get the FMLA for the next 10 weeks, and they get it at the reduced $200, 2/3 of their pay, or $200 a day, whichever is greater, right? So $200 a day is the cap?
No, whichever is less.
Whichever is less. That's my math. Whichever is less. And so at the end of the day, right, if that's what they're taking it for, ultimately they can say to you, well, I have this PTO and I prefer to take the PTO. And I think what Rob is saying is, look, if they decide they want to take their PTO, again, we want to make sure that it's their choice. We can't force them to take their PTO. And we want to make sure that at the end of the day, they realize that if they're taking PTO instead of this protected leave, that it's not protected, right? It's just under your policy.
Okay, so looking at the time here, I want to cover a couple other concepts and we'll continue to take other questions towards the end. Key thing in the FAQs that came out last week, no rights to any of these leaves after you have taken somebody off the payroll, or if you furlough them, or if you cut their hours completely. So after that, if you stay on the payroll, they may or may not continue to accrue under your policies. But as far as these rights to paid sick leave or FMLA, those end when people are separated, laid off, furloughed, reduces hours for economic reason, all of those things, all those economic reasons you don't get. We talked about the payroll tax credits earlier. I want to cover a couple other common questions and then continue to be taking yours in the time we have left. Let me.
Can we go to some furlough questions? Because
sure.
I think that we've been
sure.
getting some of those.
We'll go to the end. We talked about return to work. Let's go to the downsizing and furlough ones first. Quick one on confidentiality. It should be obvious, but all of this COVID-19 information you're collecting is confidential under the ADA, HIPAA, and lots of other things. So you should do what you can to protect your workplace and tell people that there's been an exposure. But CDC and EEOC and everybody else say you should not be disclosing names unless you have direction to do so from a public health official. So downsizing in general, well, we're in an economic downturn, and all those issues that we faced during prior recessions, same as any other struggling business, we are not going to be able to we're not touching today the CARES Act and the money that might be available now or in future monies from the feds. I think Judy's going to, the PAA is looking at that for a subsequent webinar. But you've got advanced notice requirements if you're covered by WARN. You have various provisions in your policies and contracts. But unless you've got some other policy or contract, no obligation to keep paying people when you furlough them or lay them off. Is there a difference between them? Your focus should not be on what you call it first, but what are you doing? Are you keeping your key employees in an unpaid leave? Do you want to continue their health benefits? Do you want to guarantee them a right to reinstatement? Are you going to pay them partial pay? Or are you going to take them off the payroll? They're probably eligible for unemployment comp no matter which of those you choose. But if you really want to ensure that they don't have other rights to come back on, a layoff or a separation is the most viable. But you have to look at your state and unemployment comp laws to make certain that they don't treat those things differently. If you want to make it clear they're separated, take them off the payroll, issue them a COBRA notice. But once you decide what you want to do, then you can figure out which you want to call it. Most employers are using the term furlough to mean, this is a temporary, short term, I expect to recall you soon, here's what I'm going to do for you, and you're going to stay on the payroll for those purposes. And then using a layoff for a more permanent long-term separation. Dina, anything you want to add on that?
I would just say for the larger companies who have operations in states outside of Pennsylvania, particularly New Jersey, if we're going to do large furloughs, I would also make sure that we suspend PTO policies in the interim. And one of the questions that's been coming up is whether employees who are on furlough still get current benefits like sick leave and things like that. Talk to your legal advisors about those questions, but we want to make sure that employees who are coming back from furlough, hopefully in a couple of months, still have the benefits available to them. But one of the things that some of my clients are dealing with are employees who, once they're on furlough and realize unemployment isn't giving them kind of what they want, now they are saying, hey, I want to pay out of my hours. And although we are making arguments about, well, you're not working, if you've suspended your PTO policies when they go out, then we don't have to worry about that. And I'm not sure if we answered this question, but what are we doing about employees who decide, hey, I'm going to make more on unemployment than I am working here, so I want to be furloughed? Did we answer that question already?
We haven't yet, and
That's a good one.
It is unfortunately true that in some scenarios with lower paid employees or those who have a base salary that's small but more on commission, that they may earn more on unemployment under the new act than they would otherwise. And your question at that point is, are they valuable enough that you want to let them do that with some rights to reinstatement and try to hold on to the relationship? Or do you just want to cut them loose?
Well, and also I think, an employee may not be entitled to unemployment if in fact they elect not to work anymore, if work is available to them. So it really depends on how you identify the separation. And some of my clients are doing it just that way. I have one client who said, well, this is a voluntary furlough. If you're electing not to work here anymore and work is available, and you're voluntarily choosing to furlough, and unemployment will decide how it chooses that. A lot of people, I don't remember, Rob, if on the next slide when we talk, here's PAA's resources, and PAA has a ton of resources. They're doing so much, and thank you to the PAA team for everything that you're doing. Did we put the DOL FAQ link on the resource page?
I believe we put it there, and it is earlier in the slides.
We can We can also add those resources to our resource page.
Okay, I believe Marlon does have that on the resource page. She put
Okay.
it up. But one of the questions I keep getting, Judy, is a copy of all the information, meaning the slides and this webinar going to be available after the webinar is over?
Yes, we can put it on our resource page.
Okay, so this will all be available on the resource page. I still have questions that I'm answering in the question and answer box, which I'm happy to continue doing for the next few minutes, if that's okay with you, Judy.
Yeah, that's fine.
Okay, so I'm going to just continuing answering some of these questions. So if you have questions, you can continue typing them. I'm happy to sit here and continue answering some of these questions for the next few minutes. It was a real pleasure to be able to speak with you all today. And as we said at the beginning, like, this has been such a challenge for employers, and we understand that. I mean, the laws are changing daily. The FAQs are coming out daily. The state laws are changing daily. Be ready for I know that there's a bill pending in the Pennsylvania legislature to institute some state paid leave. Whether that passes or not, I don't know. But it's changing every day. So keep up to date. PAA has been just a great resource to provide you all the information, or as much information as they can. The DOL has also put out some good information. Rob, if you go to our resource slide, we've also put out some information that's free, both on our site, and then we've given you some other organizations that have put out great information as well.
Yeah, let me just add that top link on our resource page is to the home page of, we have a COVID-19 homepage directly linked from our website right up front. And if you go there, we are updating that regularly. That's where we're going to be posting CARES information from the rest of from other groups in the firm. And we will be updating our alerts when things change on the FAQs or information. We've been updating the material on that website. So it is a place that you can hyperlink and check back periodically for updates.
So before we go on to the additional questions, let me just thank both of you for spending the morning with us. This has been invaluable information. We had our resource pages on the last slide, and you can go there for updated information on best practices in our industry during this time. Check our website for other webinars relating to the coronavirus. We will have some coming up soon. And thank everybody for coming today, and stay safe and healthy. There might be some other questions that you want to answer. Dina?
Dina?
I mean, I'm typing it. I've been typing answers the whole time.
Oh, okay.
But I think we're good.
Caught up?
Yeah, I mean, I have a couple more on this page that I've been typing in, so I'm just going to continue kind of answering as we go.
Okay.
So I would leave the web page open if we can, Judy, just for a few more minutes, so that I can get through the rest of these questions. But thank you, everybody, for your questions and for your attentiveness, and be safe.
Yep.
Thank you, everybody.